One of contract law's basic principles is that a valid contract requires the contract parties to have a meeting of the minds. In practice, this means that contracting parties must agree on the contract's substance, or they can't form a contract. So, how much agreement is enough to form a contract? The case of Wagner Excello Foods Inc. versus Fearn International Inc. explores this question. In 1985, Wagner Excello Foods, a fruit juice concentrate manufacturer, entered into a 5-year agreement with Fearn International to manufacture and sell Fearn fruit drink concentrates. The agreement required Fearn to purchase minimum annual quantities of the concentrate. The agreement included, among other provisions, an exclusivity clause, an indemnity clause, and an insurance clause. Despite these details, the agreement didn't establish the concentrate's price. Instead, the agreement required that the parties review and set the price every 4 months. The agreement further provided that if the parties couldn't agree on a price, the agreement would terminate 30 days after the end of that 4-month period. During the first 3 years of the agreement, Fearn purchased only a small fraction of the required minimum annual purchases, and the amount it purchased decreased each year. Accordingly, near the end of the 3rd year, the parties executed a revised agreement, expressly stating that it didn't modify the previous agreement other than as specified. The revised agreement primarily established a method for setting orange juice concentrate prices and provided alternative agreement expiration dates based on the date on which a party notifies the other party of its intention to terminate the agreement. In the 10 months following the revised agreement's execution, Fearn purchased only 7.1% of the required minimum annual purchase. On November 16, 1988, Fearn notified Wagner of its intention to terminate the agreement and ceased purchasing the concentrate. Wagner sued Fearn for breach of contract. Fearn moved to dismiss the lawsuit, arguing that there wasn't a contract and that their agreement was merely an agreement to agree because it didn't include a price. The trial court agreed with Fearn and granted its dismissal motion. Wagner appealed.